Hello everyone, this is Jennifer Sicasabar and welcome back to my channel. So for today's video, I am going to discuss prosecution as the second pillar of the Philippine criminal justice system. So here are the contents of our discussion for this video. So number one is definition of prosecution, role of the prosecutor, prosecutorial discretion and selective prosecution, composition of prosecution, duty of prosecutors, preliminary investigation, arraignment, plea bargaining, complaint, information, inquest, and other officers authorized by law to conduct preliminary investigation. So first, we have the term prosecution. So, after the police or the law enforcement pillar, pupunta ngayon sa prosecution ang takbo ng ating criminal justice system. When we say prosecution, it is the process or method whereby accusations are brought before the court of justice to determine the innocence or guilt of the accused. The prosecution will be the one to gather necessary evidence with the help of the law enforcement pillar. And they will be the one to determine the existence of prima facie case and file and prosecute the case in the court. So, sabi ko nga, after the police or the law enforcement pillar, sa prosecution na po tatakbo ang ating criminal justice system. So, ang pangunahing prosecution agency ng ating gobyerno ay ang DOJ or the Department of Justice. Pero hindi lang yon ang prosecutional arm or prosecutorial arm ng ating gobyerno. So, meron ding ombudsman at meron ding ang COMELEC at iba pa. So, the prosecution will be the one to determine the existence of prima facie case or yung tinatawag nating basihan that there is really a crime committed. And also, for the prosecution, this pillar will be the one to prosecute and file the case in the court. So, what is the role of the prosecutor? So, the role of the prosecutor, serving as the lawyer of the state or government in criminal cases. The prosecutor is automatically considered as the officer of the court. At the same time, the prosecutor is formally a member of the DOJ or Department of Justice under the executive branch of the government and is thus independent from the judiciary. So, pag sinabing serving as the lawyer of the state or the government, ang prosecutor ay ang kinatawan or representative ng ating gobyerno sa mga criminal cases. Okay? Ang prosecutor ay ang abogado ng people of the Philippines. Okay? Pagka may hearing, sabi ng judge, appearances. Okay? So, ngayon, pagka sinabi ng judge, appearances, magpapakilala ngayon yung prosecutor. Sabihin niya, I'm Public Prosecutor Juan de la Cruz, respectfully appearing for the government, Your Honor. Okay? Dahil ang mga prosecutor ay ang kinatawan or abogado ng ating gobyerno. They will be the one to serve as the lawyer of our government. So we have the so-called prosecutorial discretion and selective prosecution. So what are the difference of the two? So for prosecutorial discretion, the prosecutor screens and evaluate the document in order to decide whether to accept or reject the case for prosecution. So, ang ginagawa po dyan sa prosecutorial discretion, ini-evaluate ng ating mga public prosecutor yung mga dokumento whether that is sufficient na mag-file ng kaso. Okay? And for selective prosecution, the responsibility of the prosecutor is to evaluate the evidences that the police have gathered and decide whether it is sufficient to warrant the filing of charges against the violator. So, ibig sabihin, sa selective prosecution, ang responsibilidad po dyan ng prosecutor ay i-evaluate yung mga evidences na nag-gather or na-accumulate ng ating mga kapulisan, whether yun ba ay sapat at na makapag-file ng charges laban doon sa suspect. Okay. So, what are the legal factors considered by a prosecutor under selective prosecution? Sabi nga, di ba, i-screen at i-evaluate yung dokumento. So, ano nga ba yung mga factors na kinukonsider sa selective prosecution? So, syempre, the legal strength of the case. Okay. Malakas ba yung kaso? Meron bang laban yung kaso niya? Okay. Number 2, that the suspect is in fact guilty. Number 3, the willingness of the witnesses to testify. So, ibig sabihin ba niyan, lahat ba ng mga witnesses na nakalap ng ating mga kapulisan ay willing ba talagang mag-testify sa court? And also, they need to consider yung likelihood ng ating mga prosecutor na mapapatunayan nga talaga nila yung guilt ng defendant. Okay? And for controversial expression of the prosecutorial discretion, okay, the decision to mitigate the defendant's true, number 1 po dyan is reducing the charge. Okay? So, for reducing of the charge, the prosecutor uses discretion, okay, to reduce the charges. Kagaya po ng imbis na murder, magiging homicide na lang po siya. Okay? And number 2, dropping multiple counts to leave a single charge. Okay? The prosecutor can drop several charges and come up with only one single charge. So, examples are complex crimes. And for number 3, recommending leniency to the court at sentencing parallel prison sentence. So, making sentencing recommendation, it means that if the accused pleaded guilty and he is a first-time offender or a minor, the prosecutor can recommend for lighter sentence. This is the only stage that the prosecutor can make recommendation. Okay? That's why plea bargaining is very important, so that the prosecutor can recommend whether to lessen the sentence. So, who composes the prosecutor? So, we have public prosecutor or the so-called fiscal. We have also state prosecutor. We have provincial prosecutor, city prosecutor, special prosecutor, like attorney in private practice. Okay, they represent the parties or the complainant or respondent in proceedings before the public prosecutor. But still, ang mga attorney in private practice po is under pa rin the supervision of a public prosecutor. And number 2 is public defenders such as the PAO or public attorneys officers and other legal aid lawyers. Okay? So, what are the duties of the prosecutor? So, number 1, evaluate the police findings referred to them or other complaints filed directly with them by individual persons like private citizens who are victims or have knowledge of crimes, government officers in charge of enforcement of the law violated. So, number 1 duty of the prosecutor is to evaluate all of the findings of the law enforcers or police that was being filed to them, or even private citizens or victims who have knowledge of the crime. Okay, and for those government officers who is in charge with the enforcement of the laws violated. Another, aside from evaluating the findings of the police, is to file corresponding information in proper court on the basis of their evaluation on the proofs at hand. So, ang ating mga prosecutor din po ang magpa-file ng information sa court base sa kanilang mga evaluation sa mga proof na hawak po nila. And then, number 3, to prosecute the alleged offender in court in the name of the people of the Philippines. Kaya nga po sinabi natin na they will be the one to serve as the lawyer of the government. Okay? They will be the one to represent or yung kinatawan ng ating gobyerno. So, we will move on now to preliminary investigation. Okay? It is an inquiry or proceeding for the purpose of determining whether there is sufficient ground to engender a well-founded belief that a crime cognizable by the RTC has been committed and that the respondent is probably guilty thereof and should be held for trial. So, ano ba ang ibig sabihin ng preliminary investigation? Ibig sabihin lang itong preliminary investigation bilang isang trabaho or mandato sa ating mga taga-usig para madetermina kung meron bang probable cause. Okay. Yung probable cause na tinatawag po natin ay ang magiging dahilan kung kailangan i-endorse yung complaint at mag-file sila ng information sa Court of Justice. Sabi nga natin, probable cause, ibig sabihin, malamang sa hindi, sa pagtaya ng ating taga-usig, merong dahilan or basihan na isampa yung kaso sa ating hukuman. Okay? Yan ang ginagawa ng ating mga taga-usig or yung mga prosecutor. Okay? Take note lang po ha, prosecutor, ang tawag din po sa kanila ay taga-usig. Okay? So, ang prosecutor, ayan po ang ginagawa natin mga prosecutor pagdating ng preliminary investigation. So, repeat ko lang po ha, ang ginagawa ng ating prosecutor during preliminary investigation ay para i-determine kung meron nga ba talagang probable cause para makapag-file sila ng kaso or information sa ating hukuman na yun ngang tao na yun ay nag-commit ng krimen. Okay? So, kailangan nilang i-determine yung tinatawag nating probable cause. Ang probable cause po ang magiging basihan para po mag-file ng kaso or merong talagang nangyaring krimen doon. Okay? So, who are the officers authorized to conduct preliminary investigation? So, we have provincial or city fiscals and their assistants. We have also national and regional state prosecutors and such other officers as may be authorized by law. So, later on in the last part of our topic, I will going to discuss the other officers who are authorized to conduct preliminary investigation. So, let's move on to nolle or nolle proseque. So, a nolle is a request made by the prosecutor to the judge for the approval to terminate further criminal prosecution against the suspect. Okay, so take note ha, nolle proseque or nolle is a request na ginawa ng ating mga prosecutor kay judge, okay, para i-terminate yung isang kaso. Okay? I-terminate yung criminal prosecution against the suspect. Okay? What are the uses of nolle? Of course, number 1 use is reduce case overload. Number 2, reduce backlog in the court. And also to reduce delays in bringing defendants to trial. Siyempre, mababawasan po yung cloggings ng trabaho doon po sa court natin. So, let's move on now to arraignment. Okay. Ano ba yung tinatawag nating arraignment? Okay. Actually, arraignment is the legal mechanism whereby an accused is brought before the court wherein the complaint or the charge against him is read by the clerk of the court in the presence of a lawyer and the prosecutor, in which the accused is to announce his plea. Okay? Ang arraignment po, para mas madali pong intindihin, yan po ay yung pagbasa ng sakdal sa ating akusado. So, yan nga po yung, di ba, yung isang karapatan ng isang ating accused is the right to be informed of the nature of the offense he is being charged. Okay? So, kagaya po sa arraignment, kailangan pong basahin ang sakdal doon kay akusado. So, sa totoong buhay, ganyan po yun. Ganito po yun. Ikaw, example po ikaw, Juan de la Cruz, ay inaakusahan ng sambayanang Pilipino ng kasong, for example kaso niya is reckless imprudence resulting in homicide. So, pagkatapos po nun, tatanungin siya kung ano ang kanyang plea. Okay? What is your plea? Guilty or not guilty? Okay, yun po yung plea. Kung ano po yung kanyang isasagot, kung siya ba ay aamin or hindi aamin. Okay, I repeat arraignment wherein doon po babasahin yung sakdal doon sa akusado. Okay? Na yung nature ng offense ng kanyang nakumit, and then pagkatapos pong basahin ng clerk of court in the presence po ng kanyang lawyer at ng prosecutor, okay, sasabihin po niya yung kanyang plea. Okay? Aamin ka ba or hindi ka aamin? Okay? Or guilty or not guilty? And then after that, kung sasagot man po yung ating akusado, not guilty, Your Honor, then yun po yung tinatawag nating plea nung accused. So, yun nga po yung tinatawag nating arraignment. Babasahin po yung sakdal laban sa akusado. Okay? So, ngayon, nakapag-plea na ng not guilty yung akusado natin. So, meron po tayong tinatawag na plea bargaining. Okay? Ano ba yung plea bargaining na tinatawag natin? This is the process of discussing or negotiation between the defense counsel or yung tinatawag nating yung abogado ng ating nasasakdal and the prosecutor aim at reaching an agreement whereby the prosecutor uses discretion to obtain from the judge a lighter sentence in exchange for the defendants entering a guilty plea. Sa plea bargaining po, parang pong sa bargain, di ba nga, makikipagtawaran. Okay? Magtatawaran po si defense counsel at si prosecutor. So, paano nga ba nangyayari yan? So, ang plea bargaining po ay kasunduan sa pagitan ng ating prosecutor at ng akusado kung saan ang akusado ay aamin. Okay? Aamin na nagawa niya yung krimen para sa mas mababang krimen. Okay? Para sa mas mababang sakdal o hatol ng ating hukuman. Okay? So, ibig sabihin po niyan, ang plea bargaining po, makikipag-bargain po si defense counsel, no? Aamin si akusado. Aamin siya, for example, aaminin ko na ako ang nag-commit ng crime. Pero in exchange sa imbis na yun ay murder, magiging homicide. Okay? So, example, no? Imbis na murder, magiging homicide na lang siya. Pero nga, yun nga po ang kanyang ibinabargain na mag-guilty siya or magpi-plea siya ng guilty, aaminin niya na ginawa niya yung krimen. So, ibig sabihin, mapapababa din po yung ibibigay na sentensya ng ating korte. Okay? Kaya nga po, require ang private offended party, take note, rene-require po ang private offended party na po ngayon during arraignment kasi nga po, pag nagkaroon po ng plea bargaining, pakikipagtawaran. Okay? Kasi kailangan pong tanungin yung private offended party kung mag-a-agree siya doon sa ibinabargain nung akusado. Okay? So, pwede po yun. Pleading of guilty to a lesser or to a lighter sentence. Okay? That is the so-called plea bargaining. So, what are the advantages of plea bargaining? Of course, pagka nag-plea bargain yan, it allows the court to control overcrowded dockets. Alam naman natin na sobrang dami ng mga case overload sa ating court. So, it will control and it will lessen the crowded dockets in the court. It allows the prosecutor to secure convictions in bad arrest. Of course, inamin na niya, so probably magiging hatol ng ating hukuman ay guilty. Okay, and also, number 3, a necessary discretionary tool for tempering the letter of the law with an individualized justice. Number 4, acts in the best interest of the society rather than on behalf of the victim, of course. Para sa pangkalahatan po yan. And also saves victim from humiliation and trauma. And number 6, yan po pinakamaganda, there is no trial. Kasi po, there is no trial, they will come up with judgment already. How about disadvantage of plea bargaining? Ito lang po ha. It lowering of cases demoralizes the police. Syempre, di ba? Bakit nade-demoralize yung mga kapulisan natin? Of course, for example, yan ay mga high profile na mga individual. Syempre, pagkahirap-hirap nilang mga inaresto yan, tapos magkakaroon lang ng nagkikipag-bargain lang para mapababa yung kanyang sentensya. Okay? Syempre, it will demoralize the police. Number 2, it provides an opportunity for the prosecutor and defense counsel to place their economic and occupational needs ahead. Mostly in favor of the defendant. Syempre, siya yung binibigyan mo ng favor. Kasi pinagbigyan mo yung kanyang pakikipagtawaran. Number 4, it is not an evidence of repentance. Hindi po porket inamin niya yung kanyang nagawang krimen ay pinagsisisihan po niya yun. Hindi po yun. It is not an evidence of repentance, legitimacy of punishment, and rehabilitation. It undermines the basic premise of crimes and punishment, destructive and adversary method of justice, and also defendants are dissatisfied. So, let's move on now to a prima facie case. Okay? So, what is a prima facie evidence na tinatawag natin? Prima facie evidence is such as establish a fact and unless rebutted or explained by evidence, becomes conclusive and it is considered as if fully proved. It denotes evidence which, if unexplained or uncontradicted, is sufficient or to sustain the proposition it supports or to establish the facts as to counterbalance the presumption of innocence to warrant a conviction. Okay, ito po ang tinatawag po kasing prima facie evidence na kailangan pong i-establish ng ating mga prosecutor para makapag-file po ng kaso ay yung tinatawag po nating paunang impresyon sa isang kaso. Okay. Prima facie or prima facie evidence ay ang paunang impresyon sa kaso. So, ibig sabihin, paunang impresyon ay katiwa-tiwala or kapani-paniwala sa mga inihaing ebidensya. Pero, hindi pa ho ito yung tinatawag nating proof beyond reasonable doubt. Kasi po, ang proof beyond reasonable doubt na po, yun na po yung totoo. Okay? Totoong impresyon doon sa kaso. Pero yung prima facie evidence kasi ay paunang impresyon lamang po doon sa kaso na meron nga talagang nangyaring krimen, okay? Ito lang po yung paunang impresyon ayon sa inihaing mga ebidensya na maaaring meron ngang nangyaring krimen. Okay? Kung wala pong prima facie evidence, wala pong may sasampang kaso. Kasi po, ang prosecutors po natin, yun nga po, kailangan po nilang makapag-establish ng probable cause bago po makapag-file ng information po sa ating hukuman. Okay? So, let's move on naman na po sa complaint. Ano po ba ang complaint? Okay? It is a sworn written statement charging a person with an offense. So, renereklamo mo or hinahabla mo yung tao. Okay? Sworn written statement charging a person with an offense. Renereklamo mo or hinahabla mo yung tao. Okay? Subscribed by the offended party. Any peace officer or public officer charged with the enforcement of the law violated. So, ibig sabihin po niyan, ang pwede pong mag-subscribe or yung pumirma or yung maghabla ng kaso laban po sa taong yon ay pwede pong yung offended party or yung tinatawag nating victim or complainant, any peace officer or yung ating kapulisan, or any public officer na charged sa pagpapatupad po ng mga batas natin. Okay? Ito yung mga tao na pwedeng maghabla or magsampa ng kaso laban sa isang tao. Okay? Kaya po, dito po sa complaint, okay, hindi lang po yung offended party ang pwede pong mag-file ng complaint. What if namatay yung offended party? Pwede pa ba siyang mag-complaint? Okay. Kaya nga po, pwede po ang mga peace officer o yung mga kapulisan natin na mag-file ng complaint doon po sa prosecution natin or prosecution pillar natin dahil ang ating mga kapulisan, kahit hindi po siya yung biktima or pamilya ng biktima, ay pwede mag-file ng complaint sa prosecution dahil ang public crimes, yan, tandaan po natin, ang karamihan ng criminal cases ay generally public crimes. Kaya pwede pong magsampa ng kaso ang mga kapulisan natin. Okay, that is para po sa people of the Philippines. So, ano ba ang requisites ng complaint? It should be a written statement under oath, sinumpang salaysay, signed by offended party or any peace officer or public officer charged with the enforcement of the law violated. So, ibig sabihin, kung ang una pong nagsampa ng kaso ay yung kapulisan, pwede po yun. Kasi what if namatay yung victim? Okay, pwede yun kasi nga po, public crimes po yan generally. Okay, so, pwede pong mag-file ng kaso or ng complaint ang mga peace officer. Okay, di man po sila yung kapamilya nung biktima na namatay. Okay? Ano pong pagkakaiba ng complaint sa information? Okay? Ang information po is an accusation in writing charging a person with an offense. So, inaakusahan mo yung isang tao. But, it is only to be subscribed by the prosecutor and filed with the court. So, ibig sabihin po niyan, ang information po ay sinusubscribe lamang po or pinipirmahan lamang po ng ating public prosecutor. Okay? Public prosecutor po yung fiscal. Sila ang magpa-file ng information sa korte. Okay, I repeat ha, yung complaint po, ipina-file sa prosecution. Okay? Pero po, ang information, fina-file po sa court. Another po na distinction is, ang complaint po, ang pwede pong mag-subscribe, tatlo po yan. Offended party, peace officer, or public officer. Pero po, ang information, sinusubscribe lamang po yan ng prosecutor. Public prosecutor, yung mga fiscal natin. Okay? Saan po yan ipa-file? Ang information ipa-file sa court. Di naman po pwedeng ipa-file ang information sa prosecution kasi nga po ang nag-subscribe na po dyan ay si public prosecutor. Kaya po, ipa-file na po niya yan sa next na pillar, which is the court. Okay? Information is to be filed with the court. Complaint is to be filed with the prosecution. Still part of the preliminary investigation. So, ano ba ang requisites ng information? Written accusation. So, inaakusahan mo yung isang tao. A person is charged of an offense. And then, signed by the public prosecutor and the information is filed with the court. That is the difference between complaint and information. So, ano ba ang purpose? What are the purposes of preliminary investigation? Ano ba yung mga adhikain? Bakit nga ba nagkakandak ng preliminary investigation? So, number 1 is to protect the innocent against hasty, malicious, and oppressive prosecution. Ano bang ibig sabihin yan? Bakit? Dahil bago pumunta sa hukuman ang kaso, sasalain muna ng ating mga taga-usig or mga prosecutor kung meron ba talagang basihan or probable cause yung isinumpang or isinampang kaso laban sa respondent. Okay? Tandaan natin, kahit sino pwedeng maghabla, pwedeng magreklamo, or pwedeng magsampa ng kaso. Okay? So, kaya lang, para maprotektahan naman yung karapatan ng inosenteng tao, okay, or yung respondent natin, kailangan gawin ang preliminary investigation. Okay? Baka wala namang probable cause. Okay? Meron lang talagang mga taong gusto mamerwisyo. Okay? Gusto lang magsampa ng kaso. Pero tatandaan natin na pag nagsampa ka ng kaso, stress yan. Whether totoo or hindi, kahit inosente ka, or kahit wala ka namang nagawang kasalanan, pag sinampahan ka ng kaso sa korte, okay, stress ka whether you like it or not. Kaya nga po, para maprotektahan po yung mga inosenteng tao, kailangan mo nang mag-conduct ng preliminary investigation ng ating mga public prosecutor. Okay? Number 2, to spare him from trouble, expensive, and anxiety to public trial. So, tandaan natin, ang pagsasampa ng kaso, ang labanan sa korte ay gagastos ka. Kahit nga may PAW, okay, or the public attorney officers or office. Okay, kahit nga may PAW, kahit pa ma-qualify ka sa serbisyo ng PAW, gagastos ka pa rin. Okay? Yung estado, imbis na yung oras, yung mga enerhiya, yung mga kuryente na ginagamit sa korte, ay mas nagagamit sa mas makabuluhang bagay, ay sa mga totoong kaso, may basihan. Hindi na dahil magkakaroon na ng mga useless or mga walang kakwenta-kwentang mga kaso. Okay? Imbis na gamitin nila yung kanilang mga effort, yung kanilang kuryente, yung kanilang mga pagod, sa mas makabuluhang kaso na talagang may mga basihan talaga na nag-commit talaga siya ng crime. Okay? Diba? At least, pagka nag-conduct ka ng preliminary investigation, nalaman talaga nilang walang probable cause, pwede na kagad nilang i-drop yung kaso mo, dismiss na nila kagad yung kaso mo doon pa lang sa prosecution. Kasi they know na wala namang probable cause. So at least, hindi ka mapapagasto sa part mo bilang respondent, and ganun na din po sa ating gobyerno. At least, mababawasan po yung trabaho nila. Okay? And also, to protect the state itself from useless and wasteful rights. Okay? So, Section 2, ito na po yung mga officers na authorized na mag-conduct ng preliminary investigation. Actually, meron na po yan kanina. Yan po yung provincial or city prosecutor and their assistants, judges of the MTC and MCTC, national and regional state prosecutor, and other officers as may be authorized by the law. Okay? Ito na po guys, ano ba or sino-sino ba yung mga other officers na authorized ng ating batas na mag-conduct ng preliminary investigation. So, meron po tayo dyan, the COMELEC or Commission on Election. So, ang COMELEC po, pwede pong mag-conduct ng preliminary investigation po sa lahat po ng mga election cases under the Omnibus Election Code 1987 Constitution mandates the COMELEC or COMELEC not only to investigate but also to prosecute cases of violation of election laws. So, ibig sabihin, hindi lang po pagkakandak ng preliminary investigation ang pwedeng gawin ng COMELEC but also to prosecute yung mga kaso laban sa mga pagbabiolate po ng mga election laws. Okay? And we have also the PCGG. Okay? The PCGG is the Presidential Commission on Good Governance. Okay? Prosecution for violation of RA 3019 or yung tinatawag po nating anti-graft law and RA 1379 for unexplained wealth. Okay? The Office of the Solicitor General can legally represent respondent government officials in preliminary investigation in the prosecutor's office on charges of violation of anti-graft law. So, ang mga nagkakandak po ng para sa mga violation ng anti-graft law at unexplained wealth ay ang PCGG. Okay? Meron po tayong tinatawag na Tanod Bayan and his assistants. Okay? I would like to remind everyone, ang Tanod Bayan po, hindi po yan yung mga barangay tanod. No. Okay? Tanod Bayan is also known as ombudsman. Okay? Ombudsman po ang talagang tawag po dyan. But they are also known as Tanod Bayan ng Pilipinas. Okay? Tanod Bayan ng Pilipinas. So, the ombudsman is principally tasked to investigate on its own or upon complaint by any person or any form of or manner, any act or omission of a public officer or employee, including those in government, owned or controlled corporations, or which appears to be illegal, unjust, improper, or inefficient. So, the Tanod Bayan is also known as the ombudsman. So, the Tanod Bayan or the ombudsman are responsible. Okay? Responsible po sila sa pag-iimbestiga at pagpaprosecute ng mga Philippine government officials. Okay? Philippine government officials who committed crimes, especially graft and corruption. Okay? Kagaya po ng nangyari kay Imelda Marcos, kay Joseph Ejercito Estrada, they are being investigated and prosecuted by Tanod Bayan or the ombudsman. Okay, they are the one who prosecuted them, the Tanod Bayan or the ombudsman. And lastly, we have the military tribunal, which is governed by articles of war. But we have to take note. Take note lang po natin. Metropolitan Trial Judges or the NCR Manila and the RTC judges are no longer authorized to conduct preliminary investigation. But still, they have the authority to determine the existence of probable cause for the issuance of a warrant of arrest or search warrant. Okay. Hindi na po authorized na mag-conduct ng preliminary investigation ng ating mga Metropolitan Trial Judge sa Manila or yung mga RTC judges, but they are still authorized to determine po yung existence ng probable cause para po makapag-issue sila ng warrant of arrest or search warrant. And also, all of the criminal actions either commended by or complaint or information shall be prosecuted under the control and direction of the prosecutor. However, the MTC and MCTC, where there is no prosecutor available, the offended party, any peace officer charged with the enforcement of the law violated may prosecute the case. And take note, another is municipal mayors, in the absence of inferior judge, cannot conduct preliminary investigation nor issue warrant of arrest under the local government code of the Philippines. So take note, hindi po authorized na mag-conduct ng preliminary investigation ng ating mga municipal mayors at mag-issue ng warrant of arrest or search warrant. That is under the local government code of the Philippines. So, yun lamang po yung topic natin for this video. So, that is for the prosecution pillar. So, that's all for today. So, before it ends, kindly please click the subscribe button and click the notification bell for more updated videos. So, thank you and have a good day.